Thanks for this kind introduction, and thanks for Jason for the invitation. And I also want to acknowledge Roy Kreitner, my colleague from Tel Aviv. Major parts of what I'm going to talk about today are based on our work together. It is really a privilege both to be here and to be particularly in this series and deliver this lecture for you today. My talk, as the title testifies, will revolve around the prevalent and I think particularly unfortunate misconception of Anglo-American legal theory as to the proper connection between private law and the common law, or private law and adjudication. The main example I will use involves workplace safety, which fits the torts focus of this lecture series, but my claims are not limited to this specific context. So let me begin with drawing the big picture, and then I'll go over some of its details. Here's the big picture. So much of private law theory and most regulatory theory share, I argue, a double mistake. First, they both assume that different institutions, judges alone for private law theorists, regulators alone for regulatory theorists, always work with wholly different logics and without shared purposes. That's the first common mistake. The second common mistake is that they both assume that what they perceive as the core activity of each institution, again, the judiciary on the one hand, and the legislature and the regulators on the other, exhausts the type of reasoning that should govern these practices. Both assume more specifically that courts must only consider relational entitlements and regulators must solely focus on collective or aggregative conceptions of the public interest. This conventional wisdom divides the world, I argue, much too neatly, and it ignores too much necessary complexity. I do not deny that it may make sense to begin thinking about private law through common law, because adjudication provides a forum for people whose primary, that is, substantive interpersonal rights were violated, to seek vindication through secondary, that is, remedial rights. Similarly, it is reasonable to start our reflection upon the role of administrative agencies by considering cases in which the raison d'etre of their creation is carrying out a collective task that invites focusing on the collective picture. So these two are really sensible starting points, but they should not be treated as immutable pillars of legal theory. My focus here is on one side of the equation, the conventional view that private law is a matter for courts only, that private law is by definition common law, and that relational concerns are alien to the mission of the state's regulatory apparatus. This view, I will argue, is misguided. While adjudication may seem an obvious legal mechanism for addressing interpersonal injustices, there is a variety of reasons that may render it incomplete or even inappropriate for the task. In many contexts, increasingly prevalent in contemporary society, agencies, rather than or in addition to courts, are appropriate institutions for the articulation, the development, and the vindication of our interpersonal rights. Administrative regulation is often useful and sometimes indispensable for establishing and maintaining the infrastructure for interpersonal interaction in complex societies, such as the societies that we live in these days. This means that our relational infrastructure, often termed private law, is and should be the product of a joint venture of common law courts and administrative agencies. Theory may guide action, which means that theoretical mistakes are, at least potentially, also practically detrimental. Equating private law with common law may generate two such pitfalls. The first problem is that private law theory's traditional common law stricture is not capacious enough. A singular focus on courts limits the institutional and procedural imagination as to how law can, and indeed should, and to some extent does, contribute to our interpersonal horizontal relationship. The flip side of the same coin, the second practical pitfall, is that presupposing that the regulatory apparatus should be dedicated solely to aggregative tasks misses the potential that regulatory agencies wield in the interpersonal realm. By exposing the private law underpinning of what I will call relational regulators, I hope to both help make sense of existing practice, I will focus on the US, and vindicate some of its features that are currently under attack from collectivist, notably economic considerations that dominate regulatory theory. So let's finally start. I begin with considering private law and its significance, and then I turn to explain why adjudication is a typical forum for prescribing and vindicating interpersonal rights, but not a necessary one. I will demonstrate this last claim, which stand at the core of this lecture, by reference to the case of workplace safety, discussing worker compensation schemes, and especially the role of the Occupational Safety and Health Administration, what is known in the US as OSHA. I assume that there is a parallel regulatory body in this country. In conclusion, I will flesh out the lessons of this inquiry to both private law theory and regulatory theory. And I'll put my phone here so that I know when I'm overstepping my time. Okay, so let's begin with private law and its significance. The most banal definition of private law captures, I think, its normative significance. Private law is simply the law which governs our interpersonal relationship as opposed to our interactions as subject of the state or as co-citizens, our interpersonal relationship as persons, not as citizens. Private law supplies a set of considerations that focus precisely on such social contact, and the dominance of those considerations is private law's distinguishing feature. More than any other part of the law, private law sets the conditions of legitimate interactions among individuals. Private law, in other words, underpins an important subset of our quotidian horizontal relationship as persons. I'm saying a subset because there are, hopefully, in every society we know, certain other subsets that are not governed by law at all. But insofar as they are governed by law, this would be private law. Recognizing the significance of private law as the law of interpersonal relationships among private individuals does not imply a strict separation between private and public law. Rather, it relies on the freestanding significance of the social, a realm that is irreducible to the political or the statist. At its best, private law establishes frameworks for respectful interaction between self-determining individuals, and these interactions or these frameworks are indispensable for a society where all recognize one another as genuinely free and equal agents. Only private law, the law of our interpersonal, horizontal relationship, can form and sustain the variety of frameworks necessary for our ability to lead our chosen conception of life. And only private law can cast them as interactions between free and equal individuals who respect one another as the persons they actually are. In other words, recognizing both the value and the potential threat of our horizontal interactions in the array of social spheres governed by private law. Think family, work, home, community, and commerce, and obviously commerce, implies that goals like efficiency or democratic citizenship or distributive justice, important as they are, must not exhaust private law's normative concerns. Private law is a meaningful legal category quite apart from its contribution to such collective purposes. The core moral responsibility of private law lies in delineating what people owe to each other in the frameworks of social interaction. Reductionist accounts of private law, notably of the economic kind, are objectionable in this view, not because they fail in separating private from public. I do not rule out some possible instrumental roles of private law as a means to social end. But these roles must not predominate as reductionists imply. We must not ignore or marginalize private law's non-collectivist intrinsic value. As the law of our horizontal interpersonal interactions, private law's interpersonal roles cannot be performed properly by any other legal field. Eliminating the category of private law would have subordinated the social to the public, thus potentially effacing the interpersonal concerns standing at the moral center of private law. What are these interpersonal concerns? One traditional view, coming mostly in recent years from the holy city of Toronto, understands private law as a stronghold of individual independence and formal equality. But as I show, or at least I argue that I show, in other works co-authored with another colleague, Avichai Dorfman, this understanding of private law cannot withstand critical scrutiny. Any polity that takes seriously the commitment to individual self-determination, and not merely independence, and to substantive and not merely formal equality, cannot make these values irrelevant to our interpersonal relationships. Quite the contrary. These values are just as crucial to our horizontal interactions as they are to our vertical ones, although they entail different implications in these different dimensions. Private law, as we know it, is actually committed to enhancing a capacious vision of autonomy rather than merely safeguarding independence. And it does not content itself with formal equality, but rather aims at positively establishing our substantive equality. Numerous doctrines of private law, running from veteran common law rules that require potential tortfeasors to accommodate the relevant constitutive features of their victims, help solve collective action problems, or merely oblige recipients of mistaken payments to reverse mistakes for which they have no responsibility, are straightforward implications of the injunction of reciprocal respect for self-determination and substantive equality. These and many other examples supports the interpretation of private law as a realm of what I call, again in this co-authored work, relational justice. Now, this charitable reading of private law is controversial, but that controversy does not undermine my point here. Critics may offer competing interpretations of the interpersonal responsibilities entrenched in private law, and fortunately, arbitrating such controversy is unnecessary for our purposes today. It's really important, but not for our purposes today, because nothing in what follows hangs on the endorsement of this particular account. All that is needed is the modest, quite banal proposition that private law includes much more than duties of abstention, that the law of our interpersonal interactions as individuals is also the law of our interpersonal responsibilities towards one another. Okay, now compare this understanding of private law with its court-centric counterpart. One popular view of private law presents a mirror image of the conventional association of regulation with the public interest. Private law, claimed the late Peter Bergs, is defined as concerning, and I quote, the rights which, one against another, people are able to realize in courts. This view implies, for example, that workers' compensation schemes which substitute administration for adjudication should not be deemed extensions of tort law. So I'm out of this room. The shift from the domain from one-to-one litigation before a judge to the administrative apparatus implies, in this view, a jurisdictional transfer of authority from private law to public law. Now, there is much to be said in favor of courts' contribution to the development and implementation of private law. And I want to begin by saying it. Common law judges indeed carried much of this burden historically. Friends of the common law tradition, myself included, celebrate its grand style, described by one of his most important students, Carl Wellin, as, and I'm quoting, a functional harmonization of vision with tradition, of continuity with growth, of machinery with purpose, of measure with need, mediating between the seeming commands of the authorities and the felt demands of justice. Think about that. What a quote. That's not mine, so I can. So this mode of decision-making renders adjudication indeed a particularly hospitable arena for the complex task of fashioning and refashioning the legal infrastructure of interpersonal relationships. It invites judges to engage in what great judge Benjamin Cardozo called an endless process of testing and retesting. It encourages them to shape and reshape law close and contemporary to human problems they deal with, taking benefit from the discrimination necessary for intimacy of treatment. And at the same time, its typical piecemeal, gradual mode of operation retains the common law's loyalty to the two important aspects of the rule of law. The requirement that law be capable of guiding its subject behavior, and the prescription that law not confer on officials the right to exercise unconstrained power. There is another reason yet for why the connection between private law and adjudication indeed seems natural. I'm not contesting that. While the ultimate result of a system of private law is a comprehensive scheme of entitlements governing our interpersonal interactions that prescribes our primary rights and duties, private law's straightforward means of enforcement entails the arming of rights holders with the power to decide how to respond to infringement of their rights, as well as the standing to instigate a complaint. In other words, court proceedings are sensibly perceived as the obvious venue for this exercise. Adjudication is a form adjudication as a forum, adjudication as a forum is specifically designed to assess the parties' behavior vis-a-vis their interpersonal rights and obligations, and also to refine the rules that delineate these rights and obligations to begin with. Furthermore, even though the yield of the process does not perfectly mirror these rights, these gaps do not undermine the sense in which courts' rulings and orders serve as focused responses to plaintiffs' complaint given remedies participation in the constitution of rights and not only their infringement. So these are weighty reasons for the association of private law with adjudication and more generally of the importance of our access to courts. And nothing that I'm going to say from now until, I don't know, 120, 115 is going to contest that. Those observations and other observations that have been made by others explain why adjudication took and continues to take center stage in the drama of private law. But they cannot, I want to argue, justify its hegemony as the court-centric view of private law suggests. The feature that makes private law a meaningful legal category is not institutional. It is also not remedial. Rules about litigation and remedies only represent law's fallback plan that comes into effect when we fail to conform to the demands of duty. Private law's distinctive core lies instead, as I've repeatedly emphasized, in the type of considerations that supply the justifications for its substantive norms, dealing with our interpersonal interactions. And none of these advantages of adjudication, valid as they are, implies that private law only appears, thrives, or survives when it is run by judges. Quite the contrary. These advantages are contingent, and they are contingent upon a certain adjudicatory tradition and upon a set of background empirical assumptions and normative conjectures. Court-centric private law may thus be suboptimal on its own terms, namely, judge vis-a-vis the ideal of relational justice or any kind of reasonable conception of interpersonal justice. This may be the case for the obvious but practically really important reason that the existing private law institution of adjudication, alternative dispute resolution included, failed to respond effectively enough to the demands of dispute resolution. Or it can come about because their response is disturbingly affected by the respective party's ability to pay, something that is not alien to anyone in any jurisdiction that I know of, or by other asymmetrical limitations of the access to justice. And it may also derive from more general considerations. So let me say a few words about these general considerations. Complying with private law's underlying commitment to structure our interpersonal relationships so that they are governed by reciprocal respect to individual self-determination mandates the provision of an infrastructure for a secure marketplace, within which, marketplace in a broad sense of the word, within which effective choices can be made. This is a mission that often requires private law to recruit an administrative apparatus, supplementing or even at times supplanting courts. The fundamental institutional limitations of the judiciary in a complex and interconnected environment imply that fulfilling private law's relational task may necessitate regulatory underpinning. Such regulation may be necessary for several reasons. May be necessary for ensuring the generality of legal prescription, may be necessary for maintaining the required technological expertise for legal decision making, and it may be necessary for targeting the systemic market failures that can hardly be addressed on the transactional level. Furthermore, it may also be necessary in order to establish effective tools for proactive, as opposed to reactive, ex-ante guarantees of just interpersonal relationship in various social settings, and to ensure that they are sufficiently predictable so as to effectively guide people's behavior as required by the rule of law. Indeed, although adjudication is often a perfectly sensible mechanism for private law to employ, private law can be, is, and sometimes should be also made, applied, interpreted, and developed in other arenas. Establishing and maintaining a just scheme of interpersonal relationship has never been a simple matter. Modern societies are complex, and setting up an effective legal infrastructure that vindicates mutual obligation is a daunting challenge. It is thus increasingly difficult to expect courts whose modus operandi is reactive and whose perspective and information on key categories of relationship we have with our employers, with our landlords, with our banks, to name a few, the perspective of courts on those relationships is framed by specific disputes they encounter. And therefore, it is hard to expect that they would be able to face these challenges on their own. Given the comparative institutional advantages of legislators and administrative agencies on these fronts, it should be neither surprising nor objectionable to observe their heavy participation in these core tasks of private law, either in supplementing or even supplanting courts. Indeed, private law entitlements delineate the terms of interpersonal transaction. They form the infrastructure of our dealings with other people. And those rights have a range of sources. They have different institutional pedigrees. Some are doctrines familiar from casebooks in first-year private law courses. Trespass, nuisance, I've seen on the board here, right? The duty to pay damages upon breach of contract, and the limitations of that duty by doctrines of foreseeability and mitigation, the requirement of returning mistaken payments, and so on and so forth. Many more, however, are the product of regulatory agencies. The Occupational Safety and Health Administration, OSHA, my hero of today, defines, as we'll momentarily see, the duties of employers to provide safe workplaces. The Consumer Financial Protection Bureau, CFPB, determines which lending practices are unfair, deceptive, or abusive. The National Labor Relations Board, NLRB, determines rights and obligations of collective bargaining. The Office of Fair Housing and Equal Opportunity and the Equal Employment Opportunity Commission determine prohibitions on discrimination, and so on, and so on, and so on, and so on. This list is exhausting. So let me turn now to my case study. I'll deal only with one. I see, watch there. Which deals with the private law duty of employers to their employees to ensure the safety of their workplace. Abstractly analyzed, there is nothing unique in job-related injuries. Like other types of harms, some of these injuries are properly analyzed as violation of relational duties, which means that the responsibility of their prevention and the cost of their occurrence should be allocated to employers. The adjudicatory process, namely the common law of negligence, offers a straightforward way to implement this proposition. But negligence law is not essential for this task, and the shift to other means of securing compliance with these duties for pragmatic or other reasons that I've just mentioned does not imply repudiation of this prescription of relational justice. Indeed, relational justice need not, it does not, object to alternative regimes such as workers' compensation schemes that ensure compliance with the worker's duty of care. What relational justice does require is that a potential injurer be subject to an obligatory reason to accommodate, within limits, the person whom the potential victim actually is. It follows that compliance with the reason to accommodate can, if necessary, be secured without the support of the adjudicatory and remedial aspect typifying negligence law. Now, the typical workers' compensation schemes indeed prescribe that injured workers are not entitled to sue their employers or co-workers for work-related injuries. But they have not eliminated the interpersonal tort duty of care employers owe to employees. How do we know that? We know that because we see that workers' compensation schemes do not strip employees of their tort law right to bodily safety, under which they can compel their employer to ensure a reasonable, safe work environment. Indeed, the duty of reasonable care can serve as the basis for enjoining the employer from exposing employees to an unsafe workplace, so you can get an injunction. Moreover, workers' compensation schemes do not release employers from their tort liability to any injury caused by their non-accidental, that is, intentional or reckless, misconduct. Consider now the main tool contemporary law uses to vindicate workers' relational right that their employers secure a safe working environment. And that main tool, again in the American context, is the regulatory scheme prescribed by OSHA, by the Occupational Safety and Health Act of 1970. To clarify, I do not claim that OSHA mimics the results of traditional negligence law. Quite the contrary. Part of the point of this act is to generate measures that strengthen employers' ex-ante compliance with this interpersonal duty, a duty that instantiates a legitimate relation between particular employers and particular employees. Indeed, the common law of torts, with its traditional requirement of completed wrong, is particularly inapt for the task because it cannot properly respond to the irreparable harms at hand, and worker compensation schemes also do not obviate this difficulty. In particular, no award of money, I'm going to say some cliches here, but no award of money damages can restore victims of wrongful death their lost means, namely their life. And that is also true for injuries such as mangled limbs or blindness. Ex-ante regulation of risk is, at least in principle, the proper response to this predicament. Accordingly, the OSHA regime structures the relationship between employers and employees by ensuring the foundational status of employees' right to safety and health. These deviations from the common law of tort do not imply that the OSHA regime is divorced from private law's relational focus. Rather, they mean that even though its form is regulatory rather than adjudicative, this regime is in tune, in fact, way more in tune than its adjudicatory counterpart, with a focus on what relational justice requires. This relational perspective is key to important aspects of both the substance and the form of the OSHA regime. Another way to put it is that you cannot understand the statute if you don't think private law. It is most clearly manifested substantively in OSHA's prescription of feasible risk reduction. OSHA requires the elimination of significant risks when they can be eliminated without threatening the long-run health of the activity to which the risks belong. As Gregory Keating of USC explains, such feasibility analysis looks to achieve the lowest level of risk practicably, that is, technologically and economically attainable. It does not aim at getting to the level of risk that minimizes the combined costs of injuries and their prevention. Conventional regulatory theory finds this requirement puzzling, if not irrational. Some theories take this as evidence that OSHA's practice is normatively deficient or even unintelligible. And Cass Sunstein of Harvard Law School, for example, argues that because, and I quote, one OSHA regulation protects a large number of lives at relatively low cost, while another regulation protects a small number of lives at a relatively high cost, OSHA is probably unconstitutional. But OSHA's feasibility test makes perfect relational sense. Private law's relational justice underpinnings entails an asymmetrical treatment of physical harms on the one hand and financial costs on the other. This means that where the essential conditions of effective agency of the employees are at stake, risk creators should indeed be required to press precaution beyond the point of marginal cost justifiability. Furthermore, although OSHA does not establish a system of one-to-one litigation, the relational foundation of the OSHA regime can easily be traced in many features of its form. OSHA defines its general mission as the assurance of, and I quote, safe and healthful conditions for working men and women, where its own role, the role of the agency, is one of setting and enforcing standards and providing training, outreach, education, and compliance assistance, while employers, and again I'm quoting, are responsible for providing a safe and healthful workplace for their workers. This division of labor is not one whereby the state commandeers the support of employers to enhance its public goals. Rather, it rests on the typical private law relational logic. Because employers control the conditions of employment, the onus of protecting workers from occupational disease and injury should indeed rest with them as well. In other words, as the general duty clause of the OSH Act prescribes, each employer is obligated to furnish to each of his or her, should have said, employees employment and a place of employment which are free from recognized hazards that are causing or are likely to cause death or serious physical harm to his employees. This relational emphasis accounts for the rough correspondence between the list of employers' responsibility and that of employees' rights, as well as for the fact that the OSHA regime does not cover self-employed workers. Furthermore, the pursuit of relational justice is not limited to the substance of its safety standards. Thus, the relational focus of the OSHA regime nicely explains, indeed justifies, OSHA's authority to seek a restraining order if it finds conditions or practices which could reasonably be expected to cause death or serious physical harm before normal enforcement procedures could eliminate the hazard. Perhaps the starkest example of this relational rationale is, I'm saying only first, you guys are perfect, is the regulation providing workers a right to refuse hazardous work if the condition clearly presents a risk of death or serious physical harm. There is not sufficient time for OSHA to inspect, and where possible, a worker has brought a condition to the attention of the employer. While the implementation of this prescription is not necessarily straightforward, the principle is a clear case of taking a particular activity off the bargaining table. In that sense, it establishes the relational justice baseline that structures the rest of the parties' interaction. Now, OSHA is but one example of a much, much larger set of regulatory regimes that vindicate our relational rights. Another example involves consumer contracts. Here I could discuss, I won't. For example, the regime of the Consumer Financial Protection Bureau, a regime which supplements the traditional and hopelessly inadequate adjudicatory means for the horizontal task of consumer financial protection with a set of robust regulatory tools that are all aimed at making sure that banks, lenders, and other financial companies do not trick, trap, or otherwise fool consumers, but rather treat them fairly. Examples may multiply, but my time is limited. So let me turn now to some takeaways, starting from lessons for private law theory, and then I'll end up with some lessons for regulatory theory. The lessons for private law theory are more particularly aimed at a set of views. I guess that this is the traditional views, which claim or presuppose that common law rules should be the exclusive backdrop of interaction among individuals. These views place judges at the center of responsibility for interpersonal justice, and legislation or regulation on the distant periphery as alien add-ons or late-coming policy, God forbid, interventions. In this, as we've seen, these views conflate substantive considerations that ought to inform law's decision-making process, relational on the one hand or aggregative on the other, with the institution responsible for making such decisions, courts on the one hand, or legislators and agencies on the other. This mistake is consequential. Identifications between considerations and institutions are often partial, contingent, and indeed instrumental. There is, to be sure, no need to pitch battle over the proposition that courts are paradigmatically suited to adjudicating claims of interpersonal justice, while regulators are indeed paradigmatically geared toward aggregative visions of the public interest. It is enough for my purposes, and that's the only thing I'm actually claiming, is that we must know that at times agencies are a crucial instrumentality in laying the groundwork for relational justice. Relational regulator, as I call them, share with judges the common purpose of prescribing the legally acceptable terms of interpersonal interaction. Rather than a strict division of labor, the institutional overlap between judges and regulators that actually typifies the law in action in any jurisdiction that I know of is normatively the more attractive route. Appreciating the role of relational regulators in the drama of private law is crucial for private law theory because it points the way towards understanding the creation and development of the infrastructure for just relationship as the joint venture between legislators, agencies, and courts. It thus promises a more capacious account of how law can contribute to generating the infrastructure of just interpersonal interactions in modern states. Finally, let me turn to some lessons to regulatory theory. If private law theory needs to expand its institutional imagination, the lesson for scholars of regulation is that they must appreciate the significance of private law theory for their own calling. To be sure, students of regulatory agencies have long been aware of the role agencies often play in creating the ground rules for market interaction. But for the most part, existing regulatory theory views the task of regulatory agencies as serving a collective, as a collective. Regulators should, according to this conventional wisdom, ensure the efficient allocation of scarce resources, or they need to secure distributive justice, democratic citizenship, and the like. Very important considerations, just not the entire map of considerations. And in this view, regulators have no business in securing interpersonal justice. Actually, focusing on the horizontal dimension, according to this view, would distract regulators from the big picture, which is collective in nature, and thus undermine their core responsibility. Remember Cass Sunstein's dictum there. Cass Sunstein was called the czar of regulation under the Obama administration. He's not just a fancy law scholar. Appreciating the prevalence of relational regulators implies that existing regulatory theory accounts only for a subset of the regulatory practice. Those agencies, and there are quite a few of them, just not the entire picture, which carry a predominantly public task. Other agencies, what I call the other half of the regulatory universe, are better analyzed differently. Regulation often plays an important role in supplying the infrastructure for just relations among individuals. And in so doing, it does not and need not rely exclusively on aggregative considerations. The responsibility of securing just social relationship is indeed different from the responsibility of serving the interest of the public as a whole. It is one thing for the state to respect its constituents as genuinely free and equal persons. It is quite another to live in a society that expects individuals themselves to comply with the ideal of just relationships between free and equal agents. Taking this responsibility seriously requires relational regulators to think horizontally and to adjust their substantive, structural, and procedural features to the task at hand. This often already happens on the ground, as I already implied. The input of administrative determinations, to start with an easy example, into the interpersonal regime of tort law via the doctrine of negligence per se is just a straightforward example for that. When those conditions hold, regulators should weigh considerations of relational justice as animating features of their practice. But as I hope is clear by now, negligence per se is only the tip of the iceberg. Indeed, some aspect of both the substance and the form of certain agencies, which may seem off track from an aggregative perspective, become straightforward once conceptualized as responses to horizontal challenges of participating in the creation of the infrastructure of just interpersonal relationships in core social settings, such as the workplace or the market. So, for example, OSHA's prescription of feasible risk reduction, its regulation that workers are entitled to refuse hazardous work that I've already mentioned, and the fact that it does not cover self-employed workers become intelligible once analyzed as the baseline for just work relationship. Any employer is duty-bound to respect his or her employees' rights to safety and health. And the workplace is, of course, only one such interpersonal setting. The regulatory apparatus of the modern state is heavily implicated in regulating our horizontal relationship. Agencies are often central in creating or maintaining the baseline entitlement that structure relationships, while courts often engage in such baseline setting as a byproduct of particularistic litigation. Agencies do this work overtly in a manner that is more exposed to public accountability. The rules are not side effect of settling disputes, but rather geared directly to setting the foundation of the relationship. Importantly, administrative agencies are positioned to make structural decisions that courts would have difficulty formulating. And in this sense, agencies have a wider scope in setting up the infrastructure of just relationships, which courts typically address only interstitially. Because their action shapes interpersonal relationships, these agencies should be, and happily often are, thinking horizontally. Moreover, as may be expected, many of their practices and operational codes and sensibilities are in fact adapted to their task of providing the infrastructure of just relationship, and here I have an inventory that I'm going to skip, unfortunately. Okay, so, but one maybe few last words. So part of the lesson of this talk relates to the naming of the interpersonal task of existing horizontal agencies. Agencies that embrace this characterization of their task may improve their horizontal performance by consulting the preliminary relational toolkit that I hoped to mention, but I didn't. They can also, even more importantly, inform themselves with substantive theories of private law, which can be informative for the decision they need to make in the areas, the decisions they need to make in the areas which they already implicitly think horizontally. The flip side of this last point is at least, if not more, important. So let me really finish with this last important lesson. As we've seen regarding OSHA, existing regulatory theory questions the very rationality of some core instantiations of regulatory practice. But the public law reductionism, as I call it, that informs this critique is unfortunately and tragically misguided. This very same reductionism drives the increasingly strict and not sufficiently discriminating cost-benefit analysis requirement of administrative agencies. I do not claim that cost-benefit analysis should be irrelevant to relational agencies. The aggregative effect of all agency regulation does imply that the welfarist consequences are pertinent. But I do insist that the closer we come to the pole of relational agencies, for example, when we get to OSHA, the more troubling it is that cost-benefit analysis overshadows or even erases the relational considerations that should guide private law, whatever its institutional pedigree is. Thank you so much.